the honorable bench. If it may please the court, the co-counsel seeks permission to proceed with the pleadings of third and fourth issue.
Yes, please.
Your Excellencies, my third issue is about that our sections 306 and 308 in the violation of any Quranic text or Sunnah. Your Excellencies, these sections are not in violation of any text or any Sunnah, neither in the contradiction of any Islamic injections or the law of the land. But above mentioned sections are inappropriate and they have no any applicability in our case. Your Excellencies, in the light of para 13 of the factual sheet, the accused was convicted under 302 B in as the death under Tazir, but not death as Qisas. Your Excellencies, there is no any element regarding the right of Qisas in our case which may be voluntarily waived or compound by the wali in our case. Therefore, our case does not fall under the ambit of section 307B. Now, keeping in view that section 308 shall not be applied for the determination of the punishment as diyat, and so far as the situation is concerned, the section 302B PPC shall be admissible and applicable in this regard. Your Excellencies, it has not been mentioned anywhere in the Holy Quran or in any law that the heinous crime should be forgiven or vested without the prevention of that crime. Therefore, the Holy Quran also tells us about the prevention of the crime in Surah. Sorry for inconveniences. In the surah that he who transgresses thereafter shall face grievous sufferings. In this surah, it is told to us that if you are committing heinous crime, you will face its consequences. On the other hand, another surah, which is Surah Shura, it also tells us that whatever hardship befalls you is because of what your own hands have committed. This surah also guides us that if you are committing any heinous crime, it means that you are entrapping yourself in its punishment. Your Excellencies, now keeping in the view, now keeping in the view that section 308 shall not be applied for the determination, as I have already mentioned that para 13 of the factual sheet, that the learned trial court convicted accused under section 302B, death as Tazir. Later on, the High Court also maintained the same punishment. Therefore, I seek plea before this honorable court to maintain punishment under the same provision of section 302B as death to Tazir, but not as death to Qisas as per the scheme of the law. Now, moving towards my second submission, practical implication of section 306 to 308. Your Excellencies, this case will also not be relied, these sections will not also be relied uh, on our case. As section 306C states, Katleam shall not be liable to Qisas in the following cases. C. When any wali of the victim is a direct descendant, how low soever of the offender. In the light of para 7 of the factual sheet, Ali is not only the wali of offender but also of the deceased as well. And this section is mostly attracted in the cases of Qisas, but not in Tazir cases. Your Excellencies, therefore, when where 306 is inapplicable in our case, then section 308 of the PPC can't be applied except the applicability of section 302B, death is Tazir. There is a
Counsel,
case.
Council, this court has framed some issues. Number three issue is that are section 306 to 308 PPC violative of any Quranic text or the Sunnah? We need your assistance to in this issue. We don't want your assistance to tell us that this case falls under section 302A or B. We just need your assistance in the regard that these sections, section 306 to section 308, are violative of any Quranic text or not.
Your Excellencies, there is a judgment, there is a case, Muhammad Nasir versus State and others. In this case, it was held by the Supreme Court that due to the lack of the time, they could not. Uh, they actually, due to the lack of the time, there was no any amendment mentioned, but the amendment introduced in the year 1999 in the Pakistan Penal Code, including the provisions of Class C of the Section 306 and Clauses A and B of Section 304 of the PPC, with a view to bringing those provisions in conformity with the injunctions of Islam and
Counsel,
Sunnah.
Counsel, in this judgment, this is a judgment of the Supreme Court, and it is written that due to paucity of time, we have not been able to make further research in the matter ourselves. The opposite side has not assisted us on this subject. We are also Supreme Court. We need your assistance to deal with this case. So don't now refer this case and just assist us on the point. What are your submissions?
Your Excellencies, as I have already narrated, that there is no any applicability of these sections in my case because the punishment was given under Section 302B.
Council, we are not
Therefore,
asking this. We are just asking that section 306 to section 308 are violative of any Quranic text or not. Just assist us in this regard.
no, Your Excellencies, they are not in the violation of any any Quranic text. As as
Council, read the Quranic verse which deals with the qisas.
uh, sorry, Your Excellencies.
Recite the verse of the Quran that deals with the qisas. Do you know which ayah or verse deals with the qisas?
Sorry, Your Excellencies, but I have another verse which prescribes that when, if you permit, I want to read that.
Yes, please.
Your Excellencies, this ayah, this verse, as above said, verse of the Holy Quran, that he who transgresses thereafter shall face grievous sufferings. So the accused has committed heinous crime, the heinous nature of crime. Therefore, this ayah supports my case, not any verse relating to qisas, because this our case was uh, under the ambit of tazir. So I have a valid verse such as he who transgresses thereafter shall face grievous sufferings. On other hand, uh, Surat Shora's verse, whatever hardship befalls you is because of what your own hands have committed. It categorically clears the doubt in my submissions as well as in my case, that my case supports these verses, not the verse relating to any qisas.
Hello, Council. Assalamu alaikum.
Walaikum salam.
Council, how can we prove that any particular offense fall in the ambit of qisas? What are the ingredients of that?
Your Excellencies, the ingredients relating to qisas, obviously, section 3, section 302A tells us that punishment death as qisas, and there is also the fulfillment of the requirements of section 304. Either any element appears would automatically fall uh, in the ambit of Kisas.
Also,
But in my case,
read section 304, please.
yes, Your Excellencies. Uh, yes, Your Excellencies. I'm working on it. Your Excellencies, here it is, section 304, proof of Qatl-e-Amd liable to Qisas. Proof of Qatl-e-Amd liable to Qisas shall be in any of the following forms. The accused makes before a court competent to try the offense voluntarily and true confession of the commission of offense.
Stop there. True confession. What is confession?
Your Excellencies, it means that uh, with complete and full sane and wisdom knowledge, a man accepts his crime.
Now come on a note provided in instant case. In the instant case, at last you shall find the note. Do you have case?
Case, Your Excellencies.
Yes, open that case and there's written note. In the note, there is something written regarding section 304.
Your Excellencies, in my memorial, are you talking about a statement of facts?
Instant case, facts, case in which you have facts.
Yes, yes, Your Excellencies, I got it. Your Excellencies, it is clearly narrated here that due to paucity of the time, we have not been able to make further research in the matter of ourselves. The opposite side had also not assisted us on the subject. Nonetheless, the amendments were introduced in the year 1990 in the Pakistan Penal Code, including the provision of
No, no,
Class
no,
C of
no.
the section.
Counsel, read your case, instant case. At last, there is a note, note provided. Just read that note. What is written in that note? Counsel, do hurry up, please.
Sorry, Your Excellencies.
Counsel, my learned brother is asking you to read the note mentioned on Moot problem, not on your memorial.
Yes. Problem in which you have.
Yes, Your Excellencies. I have actually asked the same question. I'm working on it. Yes, Your Excellencies, I found. May I read?
Yes, yes. Read that note.
Your Excellencies, this note suggests us that there is no any issue as to whether Ahmed committed the offense or not.
Stop there. What is that? Is that not confession that your own mood problem is stating that there's no problem regarding the committing of a particular crime? This is confession, and this falls in section 304. And when it falls in 304, then Kisas is applicable. How are you applying Tazir?
Your Excellencies, whether my actually my situation from the initial steps was framed uh, in section 302B as death as Tazir.
Means you are
Your
saying that the
Excellencies,
punishment
confession.
stop. You are saying that under punishment provided under section 302B by trial courts are perfect and they must be upheld. Huh?
No, Your Excellencies, after trial court, it was actually it was approached to the Honorable High Court, and after after examining the circumstances, High Court also maintained the same situation, and I have another judgment of the Supreme Court,
High Court
which
maintained the same
also,
decision, and you are agreed on that decision.
Your Excellencies, on the behalf of victim, I
Do
am
you do
agreed
you
and I,
do you agree the decision of High Court where High Court upheld the decision of ATC? Do you agree on that?
Your Excellency, I have another judgment of
No, no,
Supreme
I
Court
don't want
to.
any judgment. Just give me a particular leading answer. Do you agree on the judgment of High Court or not?
Yes, Your Excellency.
When you agree on that, then why are you here?
Your Excellency, because uh, I want to I
What?
want to tell this honorable court that maintain punishment death as tazir as it had been maintained by the lower courts as well.
Okay, proceed on.
Thank you, Your Excellencies. Your Excellencies, as I was delivering the Peshawar High Court citation that Bhakti Rahman versus State in the light of jurisprudence of this case, it was held that Section 306 only exonerates the offender from the punishment of qisas, not from and once the offender is exonerated, his crime is punishable under Section 308. And its purview was that offense should be of the katlayam, not and liable to qisas, if the requirement of Section 304 has been fulfilled. Your Excellencies, now the applicability of Section 307 Class C. Uh, Class C of Section 307 explains that when the right devolves on the offender on a result of the death of the wali of the victim or on the person who has no right of qisas against the offender. Your Excellencies, I would like to highlight one illustration to comprehend the provision. The co-counsel seeks permission in this regard.
Yes.
Yes, Your Excellencies, such as the illustration suggests us to comprehend the provision of 307 that A tells Z that the maternal uncle of D, Z has no other wali except D, and the wife of A, D has the right of qisas from A. But if D dies, the right of qisas shall devolve on her son B, who is also the son of the offender A. B cannot claim qisas against his father, therefore qisas can't be enforced. Your Excellencies, above mentioned judgment and illustration cleared it that these sections are not attracted on our case. Hence, it is proved from the class C of section 307 PPC that the right devolves on the son and he has not granted mercy to the offender. Ali, being the wali of the victim, requests and seeks plea before this honorable court to maintain punishment as death to Tazir under the section 302B. Your Excellencies, if there is no query, then
Counsel,
the
why Ali,
co-counsel.
counsel, why Ali cannot claim the punishment of Qisas?
Your Excellencies, Section 307 and its Class C defines that just Ali is not the wali of offender. He is also the wali of the victim. So,
How
due
does
to this
section
provisions,
how does section 307 clause C knows about Ali? You are counsel, you have to prove it that whether Ali is wali or not.
Your Excellence, Section 305 uh, also explains that uh, the wali of the victim should be his heirs.
Ali
Therefore,
is legal heir of Mr. M. He said according to your statement he is wali.
Your Excellencies, uh, yes, he is the wali, but he is also the wali of the victim.
Yes, he is.
And victim because this issue does not fall under the ambit of uh, section 306, neither in under section 307 nor under section 308. If section 306 is applicable, then section 308 would automatically be attracted. But my plea on this issue is that my there is no any applicability of these sections. Therefore, I seek plea before this honorable court that maintain the punishment death as tazir under section 302B. If there is no any query regarding that, may I proceed to my second issue?
Yes, yes, proceed, proceed.
Much obliged, Your Excellencies. Your Excellencies, my fourth issue is whether the conviction and sentence recorded against the petitioner under section 302B PPC as Tazir is appropriate as per the scheme of law. Your Excellencies, my first submission starts from the bare reading and explanation to section 302. Your Excellencies, this section states that whoever commits Katleam shall subject to the provisions of this chapter be punished with death as tazir as qisas. Sorry, and its clause B tells us that punishment with death or imprisonment for life as tazir, having regard to the facts and circumstances of the case. Your Excellencies, my case falls under section 302B in the light of jurisprudence of para, para 13 of the factual sheet. It was narrated that, and it was explained in para 13 of factual sheet that the accused was convicted and sentenced by the ATC and Honorable High Court that he was convicted under section 302B as per the scheme of law. In the concerned judgment of Supreme Court and in the case of Javed Akhtar versus the state, it was held that the gravity of offense shall be taken into consideration in order to reach a determination of the particular difference. Your Excellencies, the accused committed murder of his wife. The trial court tried and awarded death penalty to him, and he approached to the Honorable High Court. Later on, the court reduced death penalty to the life imprisonment. But uh, due to his final right of plea, he approached to the Supreme Court, and after considering the situation, Supreme Court set aside the judgment of High Court, and he maintained the same punishment as the trial court maintained. Another judgment in the light of Supreme Court, Zainab versus the state. Your Excellencies, the murderer confessed the crime, and it was horrendous and barbaric offense. While taking into consideration, the Supreme Court awarded the accused death penalty under Tazir. Your Excellencies, now moving towards my second submission, in the light of law. Sorry for inconveniences, Your Excellencies. My second submission, gravity of committed crime in the light of a scheme of law, explains and relies on para 10 of the factual sheet. The gravity of crime is that Ahmed commits murder of his wife by throwing the acid on the face and all parts of the body of her and his own son during their lunchtime when they were sitting on the dining table with family in jovial mood. Your Excellencies, para 12 of the factual sheet also supports this. When he was convicted, he confessed the crime before the court competent that he has done heinous crime of throwing acid on his wife, and it was premeditated. Your Excellencies, in the light of consent judgment of the Supreme Court 200 SCMR 338, it was held that the appellant had committed heinous nature of crime, and the accused appealed to the Supreme Court for commutation of punishment. The Supreme Court uh, examined that there are no mitigating circumstances requiring the commutation of the sentence. Simultaneously, Supreme Court maintained the same punishment as death to Tazir. Your Excellencies, additionally, the state of Pakistan has recognized a few highly profiled organizations that often endeavors in favor and for the welfare of human beings, such as UDHR, Human Rights Act. Your Excellencies, they also defend the fundamental rights of masses against cruelty, humanity, torture, rape, and murder. Your Excellencies, Article 3 of the Human Rights Act 1998 also defends that no one shall be subjected to torture or to cruelty or inhumanity or degradation. In addition to that, above mentioned
Counsel,
para 10 of the factual sheet.
Counsel, what is reliability of UDHR in this case? Can Supreme Court rely on that one? Are we bound to rely on UDHR and articles of the same?
Your Excellencies, these are the highly profiled organizations which have just defined the importance of human life. I know that Supreme Court can't rely on them, but it can take into consideration uh, while keeping in view the importance of human life or their dignity. So it's just a source to elaborate the importance of human beings, and uh, they are subjected to the tortures.
Counsel, what is
Therefore,
applicability of UDHR, Universal Declaration of Human Rights, on the sections of Pakistan Penal Code, which is completely Islamic law, and UDHR is not Islamic? How are you applying that UDHR on Pakistan Penal Code?
Your Excellencies, as I have already said that it's just that organization which defines the importance of life. It tells us that uh, what is the dignity of a life actually is.
So,
And I
dignity of
have,
life, whether that dignity of life is not mentioned in Constitution of Pakistan, I think you must rely on that one. You have
yes,
to give the reference of
yes,
the same.
yes, Your Excellencies, I was moving towards that article as well after finishing it. Your Excellencies, Article 9 of the Constitution of Pakistan 1973 also, uh, actually, it is the backbone of Pakistan. It categorically expresses the fundamental rights. That this article says us that no one should be deprived of the life or liberty, and
The
as well as
Constitution describes on the fundamental rights. What are you saying?
Your Excellencies, Article 9 uh, suggests and gives us the definition of life, that no one should be deprived of the life, as my actually as Samira was deprived of her life, and she was deprived of her life dignity as well. Therefore, for supporting my argument, Article 9 of the Constitution of Pakistan, it is a supreme law. Therefore, I have narrated that Article 9 also defends it.
Council, are we
And
bound to rely
Article,
on are we bound to rely on Article 9 of Constitution of Pakistan?
Your Excellencies, as I would also say that this is just a source which describes, and it is the supreme law of Pakistan. Therefore, uh, Supreme Court can consider it that this article really describes the dignity of life,
We can
and no
consider
one.
the Constitution of Pakistan, but we are not bound to obey.
Yes, Your Excellencies, yes, Supreme Court is not bound, but Article 9 and Article 4 of the Constitution of Pakistan also
If Supreme Court is not bound to obey Constitution, it's not bound to follow Constitution, then why are you saying that this is a fundamental law which is to be applied?
Your Excellencies, Samira was deprived of her life, and it was her basic and fundamental right, obviously, to live a luxurious life. But she was subjected to
Council,
death.
what is
She
the
was
council?
subjected.
What is the source of Supreme Court? Means how Supreme Court is made, under which law it is made?
Your Excellencies, Supreme Court is a authoritative and constitutional law. So, being a
When
constitutional
it is
law,
constitutional court, when it is made under Constitution, it means that Supreme Court is bound to obey Constitution, isn't it?
Your Excellencies, it's constitutional law. Therefore, uh, it is also taken out of constitutional principles, and therefore this constitution, in the same constitution, it defines the importance of life. And Your Excellencies, uh, para 11 of the factual sheet directly mates to the painful journey of Samira when she was deprived of the life and was thrown acid upon. The later on, such event spoiled her life and passed away. Your Excellencies, as it is apparent from para 12 as well of the factual sheet, the gravity of crime, where he confesses the crime.
Council, we are running out of time. Just conclude the case.
Yes, Your Excellencies, my third submission would be concluded uh, in one citation, that there is no any such element in our case where it was mentioned that mercy was granted because the nature of the crime falls under the ambit of section 302b ppc, but not under the section 308 ppc. And Your Excellencies, in 2003 Supreme Court ruling stated that in the cases of murder, the normal penalty of death should be awarded, and leniency in any case should not be shown, except where strong mitigating circumstances for lesser sentences could be gathered. Your Excellencies, from para 12 of the fact sheet, no as such strong mitigating circumstances have been found to the trial court and the honorable court during the adjudication. Therefore, Your Excellencies, therefore, I seek plea before this honorable court to maintain punishment as death to Tazir under section 302p. Much obliged, Your Excellencies. I have concluded.
Okay, Council. Thank you so much.
Thank you. हाणे छा करणो अथई?
हाणे दिलदार अचे थो या खत्म कयूं?
हले यार ख़बर कोन्हे जी।
दिलदार जी ख़बर कोन्हे।
हाँ चलो
अॼु
पोइ
असां बेताब आहियूं व्यूज़ वठण लाइ।
हा हा उहो असल में हींअर बंदि थियण वारो हूंदो।
हाँ 2 मिनट आहिनि, just 2 minutes left।
जी जी
2 मिंट
सत
आहिनि?
लीडर्स
हाँ
अच्छा हिनखे चलो
क्लोज
ॾिसी
कयो।
अचो।